Hello viewers, this is BVI Channel 1. I am also Channel Peters. Today on Matters Arising, I have with me a very important personality when it comes to legal issues. So today we are going to have an insight on legal issue, and we are going to be delving into the right to self-determination, the constitutional right to self-determination as the Biafran people are agitating today, then justice system in Nigeria. We are going to look into all that. Then you will now form your opinion as to whether or not the Biafran people have right to what they are doing today, or probably be the judge. But let me bring in my wonderful brother. It's a pleasure meeting you today.
It's my pleasure. Thank you.
Can we know you, please?
Aloy Ejimako is my name. I'm a solicitor, I'm a barrister, advocate here in Nigeria and also in the US.
You've been involved in court processes, various suits that is ongoing that has to do with IPOB, Nnamdi Kanu, the Nigerian case in Abuja, and also some other ones outside Nigeria. Can we have an insight of all that?
Yes, the one I handled particularly, which was a special brief that I handled for IPOB and Nnamdi Kanu, and that was right before he was subjected to the attack that led to his disappearance. That particular case concerned an application, which is otherwise known as a communication, I brought before the African Commission on Human and People's Rights on behalf of IPOB and Nnamdi Kanu. The grounds for that communication are many, but the principal ground amongst those other grounds is concerning, as it concerned Operation Python Dance and its aftermaths in eastern Nigeria. The impact, the violent impact of that Operation Python Dance is something that I believe breached some of the provisions of the African Charter on Human and People's Rights. The second ground is, of course, the prescription of IPOB and the designation of IPOB as a terrorist organization, which much of the international community laughed at. We believe IPOB met the definition of organizations or groups that are dedicated to fighting for human and people's rights in nationalities that make up the signatories to the African Charter on Human and People's Rights, and Nigeria ratified that charter. So to go behind the provisions of that charter and use a law in Nigeria which I believe to be unconstitutional, even though the matter of the constitutionality of that law is probably sub judice now, but I can comment on that. The law I'm talking about is the Terrorism Prevention Act. Under that act, Section 2, subsection 1, paragraph C, empowers the Attorney General, pursuant to the authority of the President, to apply ex parte to the Federal High Court to prescribe an organization and get it declared ex parte in chambers by the judge as a terrorist organization. I believe that to be wrong. That very provision is offensive to Section 36 of the Constitution, which section dealt with the right of every Nigerian to fair hearing. Nigerians, natural persons, and organizations alike, they deserve the right to fair hearing as guaranteed under Chapter 4 of the Constitution, specifically Section 36. The Federal High Court, in declaring IPOB a terrorist organization in chambers, had relied on Section 45 of the Constitution, which derogated from certain rights guaranteed under Chapter 4 that dealt with fundamental rights. But guess what? It is very telling that Section 36 is not one of those sections that any law can derogate from. Other sections like 33, 35, 39, 40, 41, they were covered. That any law that is reasonable in a democratic society can derogate from the rights guaranteed under those sections. But Section 36 is a clear exception. So to that extent, I believe that Terrorism Prevention Act, insofar as that very Section 2 conflicts clearly with Section 36 of the Constitution is unconstitutional. So, having said that, this matter before the African Commission on Human and People's Rights is important. It's important and special in the sense that that charter has been ratified by the government of Nigeria. So it's part of our law. So anytime the government is dealing with matters that concern organizations or groups like IPOB, I think it shouldn't look to Nigerian law alone. It should also look to its international treaty obligations. Nigeria is a party. Nigeria has ratified, as I said before, that African Charter on Human Rights and also the UN Charter. Under these two charters, we have an obligation to compare and contrast as to whether we are going too far in a special moment of national emotion in dealing with certain groups that we consider to be inconvenient to the government of the day. Because at the end of the day, it's a global community. Nigeria is going to be judged in the end by the Committee of Nations on how it responds to groups like this. Groups that are doing nothing wrong, really, except that they are advocating for one right or the other within the framework of the law, within the purview of the law. IPOB, everybody knows, the international community knows, everybody knows is a non-violent organization. And I think you also need to look at the strength of IPOB. When Ojukwu was alive, he used to talk about Biafra of the mind. IPOB came to represent this Biafra of the mind. So proscribing it probably would offend the sensibilities of at least 30 to 40 million people of Igbo ethnic origin and some other people from the South that really believe that maybe to renegotiate the terms of our coexistence as Nigerians is a task that must be done. It's more important task than keeping Nigeria united by force. I think what people are saying from IPOB is give us the opportunity for our people to decide whether they want to continue to be in this union or not. It's not asking for too much. Even though someone can point to the beginning of Nigerian Constitution, which made a general statement that Nigeria is one indissoluble entity, I don't think that is a moral statement. It does not outlaw the right to self-determination. The right to self-determination is recognized internationally and has been recognized. It is the right to self-determination that through which Nigeria obtained its independence from Britain, and that right has always been exercised. So the best response to a group of people that are asking to be independent or asking for a referendum to determine whether they want to continue in the union or not, I don't think the best response is force. I don't think the best response is proscription or suppression. The best response to such a situation is a referendum, a plebiscite. It had happened before in Nigeria. If the southern or western Cameroonians, I've forgotten the geographical part of the Cameroon that was part of Nigeria until 1960, if they were suppressed and never given the opportunity through a plebiscite to decide where they wanted to be, perhaps they would have remained unhappily as part of Nigeria. But they were given an opportunity, and through a plebiscite, they were, they became part of Cameroon. And I think in 1963, a new region was created in Nigeria based on plebiscite. Plebiscite is another word of art for referendum. Midwest was created based on that because they seemed unhappy being part of Western Nigeria. So I don't think the response of the government of the day to the IPOB demands for self-determination referendum or self-determination through referendum, I don't think that response makes a lot of sense in our contemporary world. The federal government should have been well advised to exercise restraint and be extremely circumspect in listening or considering that demand. Perhaps a more watered version, maybe someone else could put something on the table. Someone could have said, listen, look, instead of referendum, why don't we renegotiate the terms of the Federation of Nigeria, or the terms of our unity? And someone might say, okay, fine, we may have to go back and consider the 1963 constitution. Nigeria was actually founded on a tripod. Let's just face it, the three big regions that came together were the federating units. That's how the British left it. But that very balance of power between the three huge regions, the north, west, and eastern region, that thing was upset from 1966 to today. So it's a matter of degree who is, running a more unitary setup or the other. Otherwise, since January 1966, we have had a unitary setup masquerading as a federation. So perhaps you could say in 1999, Obasanjo was more interested, in the federal, side of Nigeria, in federating things. He was a bit even-handed, and Yar'Adua told the same line, Jonathan told the same line. So I don't think IPOB has a personal beef with Buhari because he's Fulani, because of where he came from. Come on, Yar'Adua was Fulani, Obasanjo was Yoruba. They are not Igbos. Jonathan wasn't Igbo. So it's not a tribal thing. I think it's when government of the day decides that it's going to be more unitary than any previous government, and the unitarism is having a disparate impact on a particular set of people that consider themselves Republicans to the core, that consider themselves free men and women. It's going to, cause a little bit of a discomfort, and this is what is being expressed through that demand for self-determination. So I don't think the best response was force. It would have been dialogue, would have done a lot more good. I also don't think prosecuting Nnamdi Kanu and some of his people is also the best response. This is a political disagreement. It should have been handled politically, because if you're prosecuting him and his people and your intention is to get them convicted, for allegedly committing treasonable felony, what are you going to do with the Boko Haram leaders that you're releasing from prison and, reportedly paying some ransom money, and you're rehabilitating some of them and reintroducing them into society, and you're turning a blind eye? Not really. The government is not very activist as it's supposed to be in containing the headsman problem, but it has been extraordinarily activist in containing an IPOB that does not need to be contained. So my recommendation is very simple. The federal government should sheath its sword and adopt a reconciliatory dialogue approach to addressing the grievances that I believe to represent the vast majority of how Igbos feel. The vast majority of Igbos, even though IPOB appears to be the organization that is the poster boy for these grievances, the federal government should adopt a more reconciliatory approach and a non-judicial. The political process, I think, will be the best process for dealing with these things.
So, you made mention of a lot of things, but the striking point you made mention there is about the justice system, the way it's being handled. You talked about the indissolubility of Nigeria as provided in the Constitution, and the Biafran people are asking for the probably dissolving Nigeria through referendum if they are given the opportunity to decide where they want to go. Now, some people, on the other hand, are challenging that as far as Nigeria is concerned, with the provision of that Constitution, the IPOB demand, the Biafran people's demand, in fact, the Southeastern people's demand for referendum for Biafra is unachievable or unattainable. So the best thing to do is to jettison it, to abandon it, to boycott it, and probably move on with their lives. As a legal practitioner, what advice would you give to the people out there, both the Nigerian government and the Biafran people, as to how to go about these things? These people, on the other hand, are saying that their Nigeria is not dissolvable. Then the other people are saying, we are no longer going to be part of Nigeria. That means it's going to be dissolved. How are we going to rectify this issue?
Okay. I don't think there's any constitution, any national constitution anywhere in the world. If there is any, maybe it's just one or two that does not contain a similar provision in its constitution speaking to how indissoluble or how united that nation should be. The American Constitution considers America as one. The right to self-determination is not mentioned in the U.S. Constitution. It's not. Britain doesn't run on constitution, runs on conventions and custom and common law. But I don't believe that Britain came about thinking it's going to be dissolved. But having said that, Sudan was once indissoluble. Ethiopia was once indissoluble. In these two places, we have three different countries now. Yeah, okay, fine. Yes, I'm coming to that. And, of course, Soviet Union was once indissoluble. We have so many countries there now. Yugoslavia was once indissoluble. We have three now: Serbia, Slovakia, and the rest of it. Then we have Czechoslovakia, of course. Slovakia, that's where it came in. It was once indissoluble. So when such thing is mentioned in the Constitution, it's just a moral persuasion. It's just a wish as expressed by natives of that by citizens of that country that they want to live together based on certain principles of justice and fair play. So we cannot put the cart before the horse. Is Nigeria being run strictly in accordance with the Constitution? No. So why should we seize on that very statement alone? A lot of things are not being done fairly here. That is what is causing the problem. So that our Constitution does not recognize expressly the right to self-determination does not necessarily mean that that right does not exist. British Empire was once a very big behemoth. That was British. There was nothing in any British law that recognized the right of the natives to independence. They had to fight for their independence. So the right to self-determination is an ingrained right. It's a congenital right that you don't have to speak of in the Constitution for the right to be recognized. That is why the right is recognized under the UN Charter, under the African Charter. And it is not with respect to colonial powers alone. I have had contrary arguments from some quarters that the right to self-determination was guaranteed under the UN Charter and African Charter as against colonial powers. No. Any nationality, any identifiable ethnic nationality can articulate that right, like South Sudan did, like Eritrea did. And if you make a strong case for that, a single blood doesn't have to be shed. And of course, it is not just a few people coming together and taking that decision for self-determination and imposing it on the rest of the population. That right is subject to a referendum, and I think that is what IPOB was asking for. You should have just given them that. And if you felt that was giving too much, maybe you ask them if they could take less. I think other sections of the country, apart from IPOB, have come out to say something akin, something similar, a garden variety form of self-determination. Some call it restructuring. Some call it renegotiating the federation. Some call it true federalism. But if you look at the documents flying around, especially the one from Afenifere, from Western Nigeria, you see something very similar in character to what IPOB is asking for, which is to return back to the 1963 Constitution and work from that document and work from that get-go. And going forward, if it becomes too inconvenient, then people can go their separate ways.
Okay, now, the justice system in Nigeria, in fact, we have just witnessed something, I would say, record-breaking in the judicial system all over the world, right here in Nigeria. Some people will say things that can only happen in Nigeria. Just a few weeks ago, it's no longer in news that snakes are swallowing money, monkeys are swallowing money, even rat are pursuing president from the office. In fact, the biggest culprit in Nigeria are now becoming animals. Now, we are looking at a justice system where a judge could be an attorney for the defendant. I want to ask, because we in Africa here, you are practicing in America and also in Nigeria. So you are, I will say by far, you are an international lawyer. Have you seen that happen anywhere outside Nigeria?
Listen, it's very simple. Even a layman knows it. In several customs, let's forget about the law. In the custom of my people, according to native law and custom, if somebody brings a keg of palm wine and lodges a complaint against you and you don't respond, and you are given several notices to respond and you didn't respond, the judgment will be rendered against you. It's as natural as that. Common law recognizes that even further. If you are talking with particular reference to any case, well, there are several cases, but I can give you one gaping example. One is the case filed by Alibo Development Foundation against federal government regarding the deployment of soldiers to southeastern Nigeria under the code name of Egweke. In that very case, the federal government did not care to make any appearance, either in person or through filing of any process at all. In fact, serving them process through the sheriff was like pulling the tooth. So the attorneys had to apply for special process, special way to serve process, which was by publication, and it cost a lot of money. So that put them on notice. Yet they did not care to file a response. I believe the case should have ended right there and then, with the uncontroverted, with the uncontradicted quantum evidence filed by ADF councils. The Federal High Court should have said, well, the federal government is disrespecting this honorable court and is not contradicting anything before this honorable court, and therefore a default judgment should ensue. A judgment for failure to appear is the next best response by any court of law and equity to this kind of scenario. You don't put, you don't just go ahead and ignore that and then begin to consider the case on the merit. If you wanted to consider the case on the merit, fine. You still have to consider, you still have to factor in the fact that the opposing party failed to appear and they did not contradict any evidence that the applicant put before you. So to the extent that the integrity of the judiciary or the integrity or the independence of the judiciary is very important, I think a default judgment should have ensued to put federal government on notice what is did by not answering that suit is wrong. Then it can approach properly the same court with a motion to reopen, explaining why it did not put up an appearance. And at that point, the two issues can be joined. And the applicant will be required to make his case, to carry his burden, and the federal government will be there to be confronted. And the federal government will also have the opportunity to rebut the quantum evidence by the applicant, but it didn't happen in this case. So such a matter really, to tell you the truth, is bound for the Court of Appeal. And I believe the Court of Appeal would look at this case quite seriously to consider why such a judgment should ensue.
So, in the long and short of it all, the viewers out there are hearing it for the first time that a judge can, make a judgment as against the plaintiff, despite the fact that the defendant never appeared for the case. Thank you so much for giving us your time. It's a pleasure, honestly. I will hope you're going to have you once again on BVI Matters Horizon.
My pleasure. Anytime, any day.
To my esteemed viewers out there, you have heard it all from an erudite legal practitioner. This is just the beginning and a tip of an iceberg of what you'll be getting on this platform. We'll be having him soonest, and I hope you got every information there. Let the world out there know what is happening by sharing this video, like it, drop your comment, let's get your opinion. Don't forget to subscribe to our YouTube channel to be getting more notification and update whenever it is uploaded. You can visit our website www.bvichannel1.com. From the description below, you see our app links. Get them and you have all the information at the tip of your finger. Thank you for watching this far. I still remain as Nnamdi Peters saying God bless you, and above all, stay safe. Goodbye.